The nomination of Kurt Wall to be U.S. Attorney is listed for the first time and will be held over. We'll vote today on Whitney Hermanfer, nominee for the Circuit Judge, Sixth Circuit, Josh Devine, District Judge on the Eastern and Western Districts of Missouri, Zachary Bluestone, Maria Lanahan, and Christian Stevens to be district judges of the Eastern District of Missouri. We'll also vote on U.S. Attorney nominees Bart Davis, Idaho District, David Metcalf, Eastern District, Pennsylvania. This Congress, I've heard my Democratic colleagues relentlessly and unfairly attack Trump nominees as simply the president's lawyers. We heard the same yesterday. No matter how the nominee answers, my colleagues seem to have already made their minds up. No answer appears to be satisfactory. In light of this common refrain, I was surprised by what was said on Monday at the Democrats' own partisan spotlight hearing. In the Senate Minority Leader's remarks, he boasted that Democrats put, quote, unquote, progressive judges on the bench. He boasted about their rulings against the Trump administration, and he said, quote, our people are the first line of defense. Let me say again, our people. The hypocrisy of the other side attacking nominees as beholden to Trump when their own leader says he basically owns their nominees is in fact breathtaking. Judges shouldn't be anyone's people. They aren't supposed to advance policy preferences. They aren't part of Congress or the executive branch. They're part of a separate branch of government, insulated from politics and policy making, and they must be dedicated to following the rule of law, whether they agree with the outcomes or not. That's what I expect of judges, regardless of the party of the president who appointed them. Democrats have also repeatedly brought up the issue of following court orders. This dispute is made up. Everyone agrees that lawful court orders should be obeyed, and President Trump and his administrations have done it. But do you know who actually did ignore a court order? Judge Murphy, a Democrat-nominated judge, confirmed in the lame duck session last year. He defied a Supreme Court ruling and continued enforcing related orders anyway. Fortunately, our nominees today have a different perspective. They're dedicated to the rule of law and committed to the Constitution. And I'm confident they will abide by binding decisions of higher courts. Last Congress, according to the chairman at that time, my friend Senator Durbin, over 80% of President Biden's nominees were advanced on a bipartisan basis.
They were that good.
So I hope that we have the same bipartisan support today because we've got some truly excellent, well-qualified nominees. Whitney Hermanfer, nominated to the Sixth Circuit, demonstrated why she's been widely praised. Similarly, the district court nominees also have excellent credentials and experience and perform well in their hearing. All of these nominations have demonstrated their commitment to the rule of law and judicial independence that are essential in our constitutional system. I'll be voting for all of them and urge my colleagues to do likewise. Senator Durbin.
Thank you, Mr. Chairman. Let me begin with a point of personal privilege. I'd like to take a moment to thank my Deputy General Counsel, Jeff Hansen, for his service to my staff and the committee. After 7 years, this is Jeff's last markup. After beginning his professional life as an electrical engineer, Jeff obtained a law degree from the highly regarded Georgetown University. He left behind a lucrative career in private practice, joined the committee in 2018, serving as Senator Hirono's chief counsel, joining my staff in 2022 He oversaw the Democratic staff work on civil side, antitrust, intellectual property, bankruptcy, federal court, and many other issues. Well known on both sides of the aisles for his collegiality and bipartisanship. To take one example, he's been my lead staffer on the committee's ongoing bipartisan efforts to hold big tech accountable for their role in online sexual exploitation. Jeff has been a mentor and friend to many on the committee staff. His commitment to his colleagues is only exceeded by his love for his wife, Katie, and daughter, Charlotte. Jeff proudly wears the friendship bracelet that Charlotte made him, and he loved to keep his colleagues updated on her soccer games and ballet recitals. I wish Jeff the best in all his future endeavors, and I hope you'll join me in thanking him for his service.
Jeff, please stand up.
Mr. Chairman, yesterday the committee held a hearing on Emil Bovey, nominated to the U.S. Court of Appeals for the Third Circuit. We learned nothing that would give us comfort that Mr. Bovey is not simply on a mega mission. Is there any evidence? Well, in a social media post announcing Mr. Bovey's nomination, President Trump himself wrote that Mr. Bovey would, quote, do anything that is necessary to make America great again. President Trump's candor belies Mr. Bovey's failing memory and pledge to honor the rule of law. It is abundantly clear that President Trump nominated Mr. Bovey as a reward for his loyalty and expects this to continue. Mr. Bovey has led the effort to weaponize the Justice Department to benefit President Trump and his allies and to punish his enemies. Mr. Bovey has fired dozens of career federal prosecutors who had the audacity to work on cases related to the January 6th insurrection that were assigned to them. He told me he fired these prosecutors because they were hired by the Biden administration. But I quoted to him from his own memo, saying the terminations were because of the prosecutors' involvement in January 6 prosecutions, which he called, quote, a grave national injustice that's been perpetrated on the American people. Because of President Trump's determination to rewrite history and paint January 6 prosecutions as, quote, a grave national injustice, career prosecutors lost their careers. This is a shameful display of retribution. The day before the hearing, Mr. Erez Ruvani, respected 14-year career Justice Department attorney, filed a whistleblower disclosure with the committee. He did not leak it. He published it and sent it to us. Mr. Ruvani had defended the first Trump administration immigration policies in court. He was promoted by the second Trump administration to lead the defense of their immigration policies. In his complaint, he recounted that Mr. Bovey suggested the Justice Department might need to say, quote, F you to the federal courts and ignore federal court orders with which the administration agreed. When asked about this yesterday, Mr. Bovey said he could not recall whether he had made this statement. As Senator Schiff rightly noted, that apparently F-bombs are not noteworthy or memorable in Mr. Bovey's legal career. Mr. Bovey's actions in dismissing the corruption case against Eric Adams demonstrates he's willing to pursue President Trump's agenda without regard for the rule of law. Mr. Bovey had no credible explanation for overruling several prosecutors, including the U.S. Attorney herself, a staunch conservative who clerked for Justice Scalia and was appointed by President Trump. When asked by Senator Klobuchar, Mr. Bovey could not avoid acknowledging that the Trump administration sought to strike a corrupt bargain to drop charges against Mayor Adams in exchange for his cooperation in President Trump's mass deportation campaign. It appears that they believe Mr. Adams was too busy campaigning to be held accountable for corruption. Mr. Bovey succeeded in one thing yesterday, showing President Trump and this committee that he is a true MAGA loyalist. His fidelity to the president's cause even drew the Attorney General to our hearing. As the president ramps up his attacks against judges who rule against him, he's taken it upon himself to nominate loyalists who will rubber stamp his agenda. Are you going to speak? Want me to speak to the nominees? Or are you going to call them?
Speak to the nominees.
I'll speak to the first nominee. Last month, President Trump announced Whitney Hermanfer, first judicial nominee of his second term. Shortly beforehand, the president demanded the impeachment of a federal judge who ruled against the administration and called him, quote, a radical left lunatic, a troublemaker and agitator. I appreciate your admonition that at Spotlight hearing something was said about the judges who were appointed, and we should be careful about the language we use. But to call judges a radical left lunatic, a troublemaker and agitator, and then go on to refer to members of the bench as, quote, USA hating judges, monsters who want our country to go to hell, is hardly temperate language. President Trump's inflammatory language is part of his ongoing effort to intimidate the federal judiciary, and it also reveals what he values most in a judge. It's not experience, temperament, or independence. What he values is loyalty and a willingness to rule in favor of him and his administration. His nomination of Ms. Hermanfer shows that he expects her to be a reliable ally on the Sixth Circuit for many years to come. Ms. Hermanfer's record suggests that Mr. Trump has good reason for that expectation. Her MAGA credentials are intact. In her current role, she has argued in support of the president's unconstitutional executive order that purports to end birthright citizenship. Mr. Trump's executive order has been blocked by a judge appointed by Ronald Reagan, who said, quote, I've been on the bench for 4 decades. I can't remember another case where the question presented was as clear as this one is. This is a blatantly unconstitutional order, said the Reagan appointee about the executive order. Ms. Hermanfer has also signed briefs supporting the president's efforts to fire inspector generals and heads of independent agencies, and she's refused to acknowledge that President Trump lost the 2020 election. Moreover, Ms. Hermanfer has repeatedly chosen to litigate other politically charged issues, including challenging anti-discrimination policies of the Biden administration. She has strong ties to a range of right-wing organizations, including the Federalist Society and the Teneo Network, the secret handshakes of the right and MAGA right that are now required of key judicial nominees. Although Ms. Hermanfer's record is extreme, it is very short. That's a recurring theme in the first batch of nominees. Ms. Hermanfer graduated from law school in 2015, meaning she has less than 10 years of legal experience. And in light of the 4 years she spent as law clerk, she only practiced law for 6 years and is headed to the appellate bench. That lack of experience is a serious concern as we consider her for a lifetime position. In light of her inexperience, her partisan ideology, and her apparent willingness to support even the most lawful efforts of the Trump administration, I will oppose her nomination.
Senator Blackburn.
Thank you, Mr. Chairman. I choose to speak in support of Ms. Hermanfer, and I am so pleased that we are bringing forward her nomination this morning, and I thank you for that. She is President Trump's very first judicial nominee of his second term, and there is no one more qualified to take on that important role of an appellate judge. I could go on and on about her qualifications for the Sixth Circuit, a top grad from Princeton, first in her law school class, editor-in-chief of the Law Review. In private practice, she specialized in appellate litigation and regulatory and administrative law. She's been a law professor. On top of that, she clerked for 4 federal judges, including 3 Supreme Court justices, Alito, Barrett, and then Judge Kavanaugh when he was on the D.C. Circuit. She is serving Tennessee admirably as the Director of Strategic Litigation Unit in Attorney General Jonathan Skrmetti's office. There is no doubt that she will serve our nation well on the Sixth Circuit. She will be a tireless advocate for our Constitution. She will apply the law as it is written and not rewrite it. She's qualified to serve, and I urge my colleagues to vote to move her nomination to the floor.
On Hermanfer, the clerk will call the roll.
Mr. Grant.
Aye.
Mr. Cornish. Aye. Mr. Lee.
Aye.
Mr. Cruz.
Aye.
Mr. Hawley.
Aye.
Mr. Tillis.
Aye.
Mr. Kennedy. Mrs. Blackburn. Aye. Mr. Schmidt. Mrs. Britt. Aye. Mrs. Moody. Aye. Mr. Durbin.
No.
Mr. Whitehouse.
No.
Ms. Klobuchar.
No. By proxy.
Mr. Coons.
No. By proxy.
Mr. Blumenthal.
No.
Ms. Hirono.
No by proxy.
Mr. Booker.
No by proxy.
Mr. Padilla.
No by proxy?
Mr. Welch? No. Mr. Schiff? No. Chairman Grassley?
Aye.
On this vote, the ayes are 12, the nays are 10.
The nomination will be favorably reported. Now we go to the nomination of Zachary Bluestone. Clerk will call the roll.
Mr. Chairman?
Oh, yes, please go
I
ahead.
can have just a minute?
Yes.
Again, this nominee lacks the experience to serve in a lifetime appointment to the federal bench. He has more than 6 years' experience of the last nominee. He has seven since he's been out of law school, practicing law. Lucky for him, the Justice Department under Attorney General Bondi now refuses to provide the American Bar Association with materials on nominees. The ABA stated that it could not issue a rating based on receiving insufficient information to evaluate this nominee. But it's obvious what they could have said would have been able to look at his record in full. He does not have the experience necessary to handle the demands of the federal bench. This is not my only concern. Why is it we have to have this secret handshake of organizations endorsing and the promise of each one of these judges never, ever to acknowledge that Donald Trump actually lost the election in 2020? You cannot acknowledge that or you're gone. That's the end of your MAGA future. It would be irresponsible to support this nomination. I urge my colleagues to vote no.
Clerk will call the roll.
Mr. Graham?
Aye.
Mr. Cornyn?
Aye.
Mr. Lee?
Aye.
Mr. Cruz?
Aye.
Mr. Hawley?
Aye.
Mr. Tillis?
Aye.
Mr. Kennedy?
Aye.
Mrs. Blackburn? Aye. Mr. Schmidt?
Aye.
Mrs. Britt? Aye. Mrs. Moody? Aye. Mr. Durbin?
No.
Mr. Whitehouse?
No.
Ms. Klobuchar?
No by proxy?
Mr. Coons?
No by proxy?
Mr. Blumenthal?
No.
Ms. Hirono?
No by proxy?
Mr. Booker?
No by proxy?
Mr. Padilla?
No by proxy?
Mr. Welch?
No.
Mr. Schiff?
No.
Chairman Grassley?
Aye.
On this vote, the ayes are 12, the nays are 10.
The nomination will be favorably reported to the floor. The next nominee is Joshua Devine. Clerk will call the roll.
Mr. Chairman?
Yes.
If I can have a minute?
I'll give you all the time you want. Go ahead.
Josh Devine is 34 years old, and we're getting more experience now. 9 years since he left law school. He's taken extreme positions on reproductive rights and ballot access. He's referred to himself as, quote, a zealot for the anti-choice movement. This zealotry has been on full display in his role as Missouri Solicitor General. He has challenged women's ability to access the drug mifepristone and has undermined the decision of Missouri voters to codify abortion access in their state constitution. Previously, he wrote, quote, because we know a genetically unique human comes into existence at fertilization, abortion should not be ethically permitted, close quote. Taken at face value, it appears, although he wouldn't answer the question when I asked him, that he opposes in vitro fertilization. I asked him to explain these comments. He said that was political and he didn't have to. Apparently a fan of an elite democracy, if there is such a thing, Mr. Devine has also argued in favor, get ready, of reimposing literacy tests for voting. He argued that individuals who, quote, aren't informed about issues or platforms have no business voting. Such tests are a racist relic of the Jim Crow era that were specifically used to prevent immigrants and minorities from casting ballots. No one believes that a racist Jim Crow law should be revived. It belongs on the federal bench, period. I'll be voting no.
Mr. Chairman,
Proceed. Senator Blumenthal.
just a brief word on this nominee and the others that we're considering today to second what Senator Durbin has just said. In my view, these nominees are really outside the mainstream. They are zealots in an ideological sense that really deprives them of the kind of mainstream support and credibility that are required of nominees to be confirmed by this committee on birthright citizenship, Hermanfer, on reproductive freedoms, almost all of these nominees on so many other issues. These individuals are literally outside the mainstream. They are zealots, and their lack of scientific rigor, their problematic methodology, and undisclosed bias really disqualify them from appointment to this lifetime position on the federal bench. So I will be voting against all of them, and I think we can do better as a nation. Thank you, Mr. Chairman.
Clerk will call the roll.
No, Mr. Chairman, I wanted to speak on this.
Please do. Go
Yeah,
ahead.
I have a real problem with Mr. Devine. I do believe he goes far beyond being conservative. I think he is he's extreme. And, you know, him talking about this being a college indiscretion, I don't get that. I was in college, you were in college, and the views that he's expressed then, and I think still adheres to, are, I think, really, really extreme and have no place on the bench. And Senator Durbin mentioned a few of them. But the literacy test, seriously, having a requirement that there be literacy test, advocating that, where's that come from? It is Jim Crow, I know it, but we thought that was behind us. And his hostility about homosexuality and the things that he said about that really vilify homosexuality is terrible. And then he defended a local DJ who decided to play a speech at a white supremacist and avowed Nazi on Martin Luther King Day. I mean, that is not funny. It is not funny at all. And how in the world are we having a person who did that be considered to be a judge? It's not right. We shouldn't do that. So we're not going to get the judges that we want, but we can support judges that have a commitment to the rule of law and have demonstrated a lack of prejudice. So I think this one is over the top, and I'm going to be voting against him. Thank you, Mr. Chairman.
Clerk will call the roll.
Mr. Graham.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz.
Aye.
Mr. Holly.
Aye.
Mr. Tillis.
Aye.
Mr. Kennedy. Mrs. Blackburn. Mr. Schmidt. Mrs. Britt. Aye. Mrs. Moody. Mr. Durbin.
No.
Mr. Whitehouse.
No.
Ms. Klobuchar.
No by proxy.
Mr. Coons.
No by proxy.
Mr. Blumenthal.
No.
Ms. Hirono. No. Mr. Booker.
No by proxy.
Mr. Padilla.
No by proxy.
Mr. Welch.
No.
Mr. Schiff.
No.
Chairman Grassley.
Aye.
On this vote, the ayes are 12, the nays are 10.
The nomination will be favorably reported. Now to Maria Lanahan.
Mr. Chairman,
Please proceed.
serving as principal Deputy Solicitor General in Missouri Attorney General's office, Ms. Lanahan has been in the forefront of litigating cases on politically charged issues, including restricting access to reproductive rights. Ms. Lanahan has served as counsel of record for Missouri in an effort to restrict access to mifepristone, one of the 2 drugs used for medication abortions, despite the fact that decades of peer-reviewed research has found it to be safe. It is notable, and I want you to note this one. She argued that Missouri has standing to bring this case because access to abortion medication is, get this now, quote, depressing expected birth rates for teenage mothers in plaintiff states. She also claimed that Missouri would be injured because a loss of potential population would lead to, quote, diminishment of political representation and loss of federal funds. Those were her arguments. She argued in briefs that abortion medications are dangerous drugs. She claimed in response to written questions she was unaware of more than 60 studies supporting FDA's approval of mifepristone. Ms. Lanahan's responses to other questions indicate she's unwilling to cross the Trump MAGA line. She refused to say who's entitled to protections under the First Amendment. She refused to say whether every individual in the United States is entitled to due process. She refused to say what the federal government lawyer's duty of candor is to the federal courts. Her refusal make it easy for me to refuse my vote for Mr. Lanahan, and I ask consent that this letter be entered into the record in opposition to her.
Without opposition, so recorded. Call the roll.
Mr. Chairman, I'm sorry. Hello. I don't think you
Senator
can see me
Romano.
when I raise my hand.
You may speak.
May I speak on this
Yes.
nominee? So, Ms. Lanahan has spent her career working to dismantle and roll back civil rights laws, not uphold them. When she worked at the Missouri Attorney General's office, she filed an anti-choice lawsuit in a single judge division in Texas instead of in the district courts in Missouri. Why should we confirm someone to a district court that she judge shopped away from? Further, she's an active member of the Teneo Network, an organization affiliated with Leonard Leo, which is meant to serve as, quote, a pipeline, end quote, to place conservative positions of influence and to crush liberal dominance. I am voting no on her. And by the way, I raised my hand regarding Mr. Devine, and I just want to note that I asked for the record questions relating to whether it was important to protect witness safety in criminal proceedings, whether that was important, and whether protecting court staff and personnel from harm by litigants and their supporters is important, and he refused to answer. All he had to say was, yes, that's important, and he refused to answer that. So I just wanted to make that point, and I did raise my hand. Thank you, Mr. Chairman.
Clerk will call the roll.
Mr. Graham.
Still yes.
Mr. Cornish.
Yes.
Mr. Lee.
Yes.
Mr. Cruz.
Still yes.
Mr. Hawley.
Aye.
Mr. Tillis.
Aye.
Mr. Kennedy. Mrs. Blackburn. Aye. Mr. Schmidt. Mrs. Britt. Aye. Mrs. Moody. Aye. Mr. Durbin.
No.
Mr. Whitehouse.
No.
Ms. Klobuchar.
No by proxy?
Mr. Coons.
No by proxy?
Mr. Blumenthal.
No.
Ms. Sorono. No. Mr. Booker.
No by proxy?
Mr. Padilla.
No by proxy?
Mr. Welch. No. Mr. Schiff.
No.
Chairman Grassley.
Aye.
On this vote, the ayes are 12, the nays are 10.
The nominee will be reported. Now we have Christian Stevens.
May I speak, Mr. Chairman?
Yes.
Mr. Chairman, Judge Stevens wrote a law review article defending the infamous 100-to-1 sentencing disparity between crack cocaine and powder cocaine. Given the well-documented lack of justification for the crack cocaine sentencing disparity, its devastating impact on marginalized communities, and the harm it's caused to public trust in our justice system, I asked him whether he stood by his law review article today. He claimed that he was merely citing the position of proponents of the sentencing disparity to justify his statement that, quote, there even may be evidence to suggest that some sentencing provisions, in fact, are beneficial to the black communities hardest hit by crack epidemic. The record is clear. The crack powder cocaine sentencing disparity has disproportionately impacted people of color, with 81% of those convicted of federal crack offenses from 2015 to 2019 being black. I led the Fair Sentencing Act of 2010, a bipartisan compromise which reduced it from 100-to-1 to 18-to-1. In 2018, President Trump signed into law the First Step Act, which made the Fair Sentencing Act's reduction retroactive. The fact that Mr. Judge Stevens continues to stand by an article that defends the crack powder cocaine sentencing disparity is unbelievable. I also asked Judge Stevens in written questions whether he denounced the January 6th insurrection. He responded in this way, saying the use of the word insurrection drew a legal conclusion and that it would be inappropriate for him to comment on, quote, highly contested political issue. The fact is that a violent mob ransacked the Capitol complex, and many of us witnessed it firsthand in an actual attempt to obstruct the counting of the ballots in the Electoral College that led to the deaths of 5 police officers and injuries to 140 other policemen. If Judge Stevens can't acknowledge these basic facts and denounce the violence perpetrated against law enforcement this day, I can't support his nomination.
Clerk will call the roll.
Mr. Graham.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz.
Aye.
Mr. Hawley.
Aye.
Mr. Tillis.
Aye.
Mr. Kennedy. Mrs. Blackburn. Aye.
Yes.
Mr. Schmidt.
Aye.
Mrs. Britt. Aye. Mrs. Moody. Ms.
No.
Mr. Whitehouse.
No.
Ms. Klobuchar.
No by proxy?
Mr. Coons.
No by proxy?
Mr. Blumenthal.
No.
Ms. Hirono.
No.
Mr. Booker.
No by proxy?
Mr. Padilla.
No by proxy?
Mr. Welch.
No.
Mr. Schiff.
No.
Chairman Grassley.
Aye.
On this vote, the ayes are 12, the nays are 10.
Christian Stevens will be favorably reported to the House. Now we can have a voice vote on Bart Davis for the U.S. Attorney District of Idaho. Those in favor say aye.
Aye.
Those opposed say no.
No.
Who wants to be, you want to be recorded? Yeah. Blumenthal, no.
Mr. Chairman, Senators Booker, Padilla, and Blumenthal have asked to be recorded no.
Okay. Schiff,
No.
Yeah. Okay. Now we will, so that, the ayes have it, and that will be favorably reported. Now we work on U.S. Attorney, Eastern District of Pennsylvania, David Metcalf. Those in favor say aye.
Aye.
Opposed, say no.
No.
The ayes have it.
Mr. Chairman,
Chairman,
Please go ahead.
Mr. Chairman, Senators Booker, Padilla, Welch, I'm sorry, Senator Welch is here, and Blumenthal have asked to be recorded no, joined by Hirono
And Schiff.
and Schiff.
Mr. Chairman, had there been a recorded vote on this nominee, I'd like to state that I would have voted no.
Okay?
And myself. Durbin.
Yeah. Okay, the ayes have it, and the nomination will be favorably reported. Meeting adjourned.